So this session is planning and zoning regulations for solar. We've had a similar session a couple years ago. We've also had multiple sessions for wind. And so it's a big part of the component of how it is that the siting process works. And so my experience in planning and zoning is that, you know, somebody somewhere is going to make decisions. Somebody somewhere is going to decide. So you either have local control, you have state control, you have some sort of potential regional control in some cases, or you have federal control, or in the absence of any of those, it's a very small number of folks with money that make the decisions. So I've always been a strong believer that local control is the best. And it's not easy, it's not simple. It wasn't intended to be easy and simple, but of all the different forms of control in terms of helping chart our course and our future and how it is that we move forward as a community, it is, in my opinion, far and away the best, because it is the one that is most likely to know and understand what it is that local folks are thinking and what it is that they want to do. And of all the different forms of decision making, it is the one that far and away has the most vested interest in, first of all, getting it right, and two, because they actually live with the consequences of what they do, they have a vested interest in fixing it if they get it wrong, and that happens. But so there is, of all the different forms of decision making, this is one that is, I think, the best, and that doesn't mean that you get everything you want all the time, but it is still the best form of decision making. So I got started helping get Madison County planning and zoning established in my former life as an NRD official in the mid-70s. So I would guess somewhere in the course of my career, either but through Farmers Union, we've helped a very substantial number of the counties in the state get planning and zoning adopted. And we've done that by simply having counties that are already have planning and zoning in place and helping them look at those different counties and say, who do you think, there's different ways of doing this, which ones make the most sense. And in the end, it's not our job to tell you what it is you want to do or how you want to do it. It's your job at the local level to pound these things out. So I'm always a fan of this topic and this issue. And so we have some good folks to hear from today. Lee Greenwald is an attorney with Baird, Holm, and he does a lot of this kind of legal work. And so we thought we would start with him, who can kind of lay out the basis of kind of how it is this thing works. And then when we're done with him, Ryan Zimmerman is the chairman of the Pierce County Planning Commission and also a landowner. And then we have John Cannon, who's the executive director and legal counsel of the Nebraska Association of County Officials. And I would also say that as we interact with our partners at NACO, we also ask them on an annual basis, what are things that we could do that would be helpful for your folks in this area where our missions overlap? And so we always try to make these things educational and helpful so that local officials can, if they have a mind to, they can go to this website with the Nebraska Wind and Solar Conference, and they can look at it and they can say, well, here's these folks' take on this issue. So, and with that, it's my pleasure to bring Lee Greenwald forward. Thank you.
Thanks. Good morning, everyone. My name is Lee Greenwald. I'm an attorney with Baird, Holm in Omaha, and we represent a number of solar developers. And as a result, we spend a lot of time with local planning and zoning officials and landowners in project areas, either implementing or amending their solar regulations. And I think John will get into a little later how many counties in Nebraska actually have implemented solar regulations, but more often than not, we're finding that we're implementing them from the ground up when we go in with a project. And as a result, a lot of times we're dealing with local officials and landowners who don't have prior exposure to solar development. They're not familiar with the technology a lot of times. They may be subject to some misinformation, or there may be concerns in the community from landowners who are frankly just against a change from traditional agricultural uses of the land. And so there's a lot of challenges there. But we find that typically with just a little bit of education and continuing communication, then we can all get on the same page regarding the technology and its benefits, and then we can get down to brass tacks and start discussing some common sense solar regulations. So with that, kind of jump in. And before we get into the why or how, I thought we might just get into some of the basics of the solar facilities. And I know for this audience, some of this will be elementary, but I want to make sure that everyone's on the same page and understands the varying types of facilities that fall under these regulations. So first of all, there's three primary types of solar conversion systems. They're listed here, and we'll just briefly go through them. Individual facilities are going to be single use, support a single property business purpose. Here's an agricultural well. Pretty self-explanatory. They're going to have small output. Community solar conversion systems, they're going to have a shared use or ownership and still serve a isolated purpose, but it's going to be a larger community, obviously. And you can see they're typically between the 20 kilowatt and 5 megawatt in size. And then the subject of today's discussion, and really the hot topic in planning and zoning boardrooms across the state, are the commercial or utility scale solar conversion systems. You might hear both of those terms. They are interchangeable. The kind of traditional method is to define a commercial solar conversion system by the output. So 5 megawatts is a starting point that you'll see in a lot of regulations. One of the things that we've been approaching counties with, or other municipalities, is saying, let's define them by their land use rather than their output. The assumption there is that solar panels are going to, as the technology improves, increase their output with less land use. And so we might suggest to local officials that you define a commercial solar facility by its acreage or actual land use, since that's the consideration that really comes into play. Physical characteristics. The only reason I have this up here, I know you all have been walking by solar panels for days now, and there's some great exhibits upstairs if you want to go and touch one. But a lot of counties have questions about the environmental impacts, and a lot of the information about potential environmental detriments from solar panels, typically they talk about when they're decommissioned, are from old technologies. The modern solar panel, as many of you in this room are aware, essentially consist of the materials in your cell phone. So it's aluminum, glass, silica, a little bit of copper wiring. If there is heavy metal, it might be in solder for electronic components, just like any other electronic component. So they're typically 6.5 by 3.25 feet in size, and they're going to sit on steel racking. It does not have concrete foundations or anything permanent. They drive it in, it can come right out. And here's a picture of some happy people walking through a solar facility to give you a sense of the scale. And you can see they're spaced about 25 feet apart, which is about enough to drive a full-size pickup through. And we say when they're tilted, they're about the height of full-grown corn, or under 15 feet. So just a quick refresher for those of you who might not be familiar with the technology. The zoning regulations are typically going to have 3 sections for those varying types: the individual, the community, and the commercial solar facilities. A lot less stringent regulations on the first 2. They're smaller. It really comes down to more of a building and safety permit type issue. But the commercial ones obviously are what we're going to get into today. So who regulates them? We have FERC, which we're not going to get into today because today's topic is zoning and planning. But it really comes down to state, and as John mentioned, primarily local governance. So the state government is really, the governing body is the Nebraska Power Review Board. And the takeaway here is there are statutory requirements for these qualifying renewable facilities for interconnection, environmental consultation, and decommissioning. And as long as the facilities meet those requirements, then they're not subject to a discretionary approval process under the Power Review Board. That said, the Power Review Board still has authority to regulate and enforce those statutory provisions, but otherwise their role is fairly limited. So then we get to the local level. A majority of the regulation does occur at the local level. And so we ask, what zoning regulations should municipalities have? And before we get into the specific provisions, the first thing I'd like to address is just the overarching purpose of the regulations. And this is something we try to impress upon county officials when we go in. Well-written regulations should balance the interests of the participating and non-participating landowner. Seems pretty self-explanatory. It's a good idea to define in your regulations that participating landowners are landowners who have entered into leases, easements, or other agreements, and keeping it broad, because then you don't get into discussions about, well, as an impact easement, does that make me a participant? And we think probably yes. And so if you define it broadly, then you reduce some ambiguity there. Non-participating landowners is self-explanatory. And I have developers, yes, developers too, because somehow that continues to get lost in the shuffle. If you want to attract solar development to your community, then you have to consider the goals of those that design, fund, and build the projects. So municipalities really do hold the keys on these projects. I thought it was noteworthy that at the CEO speech yesterday, they were talking about how one of the more challenging aspects right now is the actual land and getting these permits through. And I think a lot of that challenge comes from fear of the unknown. We talked about how few counties actually have these regulations in place and how few are comfortable with the technology. And so the first thing we want to go in and say is don't be scared. There seems to be this pervasive fear that if you pass solar regulations that are going to allow solar development in any capacity, that suddenly the county is going to be covered in blue panels and it's going to look like a microchip from above. And that's just obviously not the case. So it's important to reinforce that the solar facilities are subject to conditional use permits. And so the county or other municipality is still going to hold the keys and still have approval and oversight over any independent project application that comes before it. So the mere passage of solar regulations does not create a wild west of solar development, so to speak. And a lot of people are fearful of that. And so that's something that is one of the first messages that we try to get across. And what they do is provide a framework to evaluate the individual applications. So when it comes to the specific zoning provisions, the first thing the municipality has to decide is where are we going to allow them. Obviously, we know that they typically are placed in agricultural or transitional agricultural districts. We try to impress upon municipalities that it's a good idea to allow them as a conditional use in other districts. You might not be envisioning that at the time, but since you have that conditional permit process in place, you've always got the ability to deny a project if it doesn't fit with your goals. But you might catch an application in an area that you weren't thinking of. We know in this room how solar panels can go on roofs, on the top of municipal buildings, and outlets, wherever you might be able to find space. They're pretty flexible in that way. And so I think it's a good idea to allow them as a conditional use across the board and then take those applications on a case-by-case basis. Setbacks are obviously a discussion that's always going to occur. We always get into it with opponents. The opponents arguing for greater setbacks, of course, and developers the opposite. It is an important tool to balance the interests of the participating and the non-participating landowners. But one thing that we always try to impress upon localities is that it really does infringe upon a private property right if you create too large of a setback. As you've heard multiple times through this conference today, private developers do not have the power of eminent domain. And so every application that's before the planning commission or the county board is going to have a willing participant, a voluntary landowner who wants that project on their property and is going to economically benefit from it. And every time you increase the setback, you reduce the number of those landowners. Landowners with smaller parcels may not be able to participate. Landowners with a limited buildable area on their property may not be able to participate. And so it's always important to keep that voluntary participant's point of view in mind, because that's another thing that does tend to get lost in the shuffle when you start negotiating on these. The setbacks themselves should be specified from the various receptors. We have the non-participating property lines or residences. For solar, it's typically property lines. You don't have the consideration of an equipment failure like you might a wind turbine where they want to keep a certain distance from a residence. With solar panels, really the property line setback is far and away the most common. And there's typically no setback for participating property lines or residences. The participants know that facilities will be constructed on their property, and they know that they'll need to interconnect to facilities on other people's property. So you may see setbacks from public right-of-ways, or you may just see that the setback from the underlying zoning district applies there. Visual screening is another common topic. It's really the practice of obstructing the view of the facilities using any methodology. Some counties will get very specific in the methodology that's prescribed down to the number of trees and distance and height, and some will just have general requirements. One thing that we always try to impress upon localities is that they should include the ability to use natural features and topography as a screen. That's going to be more cost effective for the developers and encourage development. And it's also going to create a more natural landscape when that screening is done rather than new rows of trees or new fences. Be wary of the property line screening requirement. I can't tell you how many times we've run into this where they'll say, the regulations will say something like, any property that has a residential use must be screened along the property line. Well, in agricultural settings, that could be a half mile long, that property line. The residence may be way over here in the corner. And so what you're doing is you're creating an extremely burdensome screening requirement on the developer, and also creates a lot of land disturbance. A lot of property owners don't want that much land torn up across their property line. So the best practice is to limit it either to the face of the residence, that surface area, or to extend it a certain amount on either side. Lancaster County, for example, requires screening for the surface of the residence plus 75 feet on either side, and that's if the residence is within 300 feet of the facilities. And so the best way to do it is to qualify both screening is triggered when the project is within an X amount of feet from the facilities, and screening is limited to the surface area of the residence or maybe an additional footage, but definitely not the whole property line. It will have the effect of chilling development, and again, it's a lot of land disturbance. Speaking of the land disturbance, a good screening requirement should authorize the adjacent landowners to waive it if they want to. We run into this a lot. There's a lot of people that don't mind looking at solar panels, that they much rather waive that requirement than have a row of fresh trees or a fence or whatever the case may be. In line with the screening, these are other site considerations. You can see some examples. That one does look like it might have been a property line screening requirement, so great example choice by me. But otherwise, you can see we'll plant native grasses. That helps with runoff and stabilizing the soil. Pollinators keep the land fertile and allow for quicker rejuvenation upon decommissioning. And these are all other things that you can consider in your zoning regulations. So decommissioning. Decommissioning is far and away the hottest topic and the one that we spend the most time discussing with local officials when we go into implement zoning regulations. There's a lot of misunderstanding about Nebraska's regulatory framework for decommissioning. And the good news about it is that it's really pretty comprehensive in its protection of landowners. And I'll get into why, but this is something that a lot of localities have trouble understanding at first and have a lot of questions about. So it's something that you should be prepared for when you're going in to discuss solar regulations with them. So the basic decommissioning requirements, and obviously decommissioning, I will say, is the practice of simply removing the project at the end of its life cycle. The basic requirements are simply when to require decommissioning. So typically that's going to be 6 months or a year after the project stops producing energy. And then how long do we have to take the project out once that obligation is triggered? And again, that's usually 6 months to a year. I include in here, it's a good idea to allow the municipality to extend that time if they want to at their option. There's a lot of things that can happen for repair or repowering, and it might make sense for the parties to extend that. So it's always good to give yourself flexibility on the municipality side. Okay. So the decommissioning plan, this is something that you typically offer to the municipality as part of the conditional use permit process. The decommissioning plan is going to be the document where the developer outlines the means that they're going to use to remove the project at the end of its life cycle. And it's also going to include, arguably more important than the description of the means, the decommissioning cost estimate. And the reason the decommissioning cost estimate is so important is because it becomes the basis for the decommissioning security, which is really the protection that the landowners and the municipalities have. So the decommissioning cost estimate should be prepared by a licensed engineer or other qualified professional. Typically, you prepare one as of the date of your application or the date of commercial operation, as the case may be in the regulations. And then that cost estimate is for the net decommissioning cost. That's important. It should include the salvage value of the project components, the resale value, because the net decommissioning cost is the actual cost to the party that decommissions the project. So the regulations are, the typical requirement is for that cost estimate to be updated every 5 years. And so developers should be pretty familiar with that requirement if you're in Nebraska. But the developer and the municipality will then enter into a short decommissioning agreement, which incorporates the plan and the cost estimate and provides for the terms of the financial security. Decommissioning security, this is the big one. The most common thing when we walk into county boardrooms is a fear that we're going to get stuck holding the bag with, I'm sure you've all heard this, we're going to get stuck holding the bag with a defunct project in the field. And the good news is in Nebraska, that should not happen. There's plenty of protections in place. But it's a concern that I've run into nearly universally when I'm implementing these regulations. And so the decommissioning cost estimate, or excuse me, the decommissioning security is the protection against that. It's typically a bond letter or letter of credit or other equivalent instrument, which other equivalent instrument is almost always a parent company guarantee or something like that. Typically, the decommissioning security requirement is delayed until the 10th or the 15th year following the commercial operation of the project. And the reason for that is because the net decommissioning cost is usually negative in the early stages of the process. In other words, the salvage and resale value of the components exceeds the cost to take it out. And so you can't really buy a negative bond, but if you do, you're really ending up giving proceeds to a bond company that don't benefit the municipality, they don't benefit the developer, and so for that reason, it's not something that's beneficial to anyone. Another approach is to require that decommissioning security upon the decommissioning cost estimate update that brings that net decommissioning cost positive. In other words, as soon as I'm updating my decommissioning cost estimate every 5 years, as soon as I get one that says there is a positive decommissioning cost, that's when my obligation is triggered. And then every 5 years, as you update your cost estimate, you'll also update the amount of your security to match that. So what that does is it ensures that the municipality always has a tangible security that they can draw upon in the event the developer does not honor their decommissioning obligations. So. And again, why not offer, a lot of localities will ask, so why not require the decommissioning security right from the start? Again, it discourages development. And for context, the Nebraska Power Review Board and state statute requires decommissioning security 10 years following the commercial operation date. So if you communicate that, then that typically provides a good independent baseline for that decommissioning requirement. The 3 layers of decommissioning protection, and there are 3. Typically, every project is subject to 2 of them. Number 1 is the landowner agreements. The lease or easements with the landowners for the project is going to have requirements for the developer to decommission the project and restore the underlying property. And the landowner will have a contractual right to enforce those decommissioning requirements in the event the developer defaults. Second, we have the county regulations. As we just discussed, the decommissioning security and all of that in the county regulations. And if there are no county regulations or the county regulations are silent on that point, then we have the state backstop from the Power Review Board. And that says that, again, if there are no zoning regulations that govern, then the state statute and the Power Review Board will require a decommissioning plan and decommissioning security upon 10 years of commercial operation of the project. So in that way, the protectionist mindset, protectionist counties can be reassured that you've got 3 protections. And even if the county doesn't protect you, you've got the state backstop. Lastly, road use and maintenance. This is another a common question. Obviously, large construction projects have a tendency to damage roads or to require changes to roads. The developer and the municipality plan these in advance, the routes that will be taken for hauling equipment and constructing the project, and then they enter into a road use and maintenance agreement. That agreement requires the developer to be responsible to repair any damage to the roads. And it also may require a bond or a letter of credit, financial security for damage to any roads. And one of the great things that we try to impress upon the localities as well is you can't replace an old road with an old road. So if you need to replace a 40-year-old road, then you get new roads in the county. And a lot of times there's a very tangible benefit to those locations. So I had your questions. I don't know how we're doing on time. I had one more.
Yep, one more slide.
How far am I?
Yeah, we're
Okay.
we're okay that we need to
Yep.
wind it up.
So the last thing I just wanted to say is, why are we doing all of this? We've got the property tax benefit is by far the biggest selling point. The municipalities often ask us how these projects are taxed. Again, it's $35.18 for the nameplate capacity per megawatt per year, and then the developer pays real property tax on the underlying improvements. So a good rule of thumb is a solar project will pay approximately $4,000 per year in taxes for each megawatt. And you can see here, this is a breakdown from a real representative property in Nebraska. This is what it would look like for a 200 megawatt solar project. And you can see the county receives a little under $200,000 annually. And the school district in the county, based on the Nebraska tax levy, would receive over $500,000 annually from a 200 megawatt project. And so when we go in and they say, why we're frustrated with this process, why are we implementing these zoning regulations? Why do we need solar development in our county? These are great points to bring up. With that, I'll turn it over to my colleagues. Thank you very much.
Thank you. Well, thank you, Lee. You did a really nice job of helping set the stage and the background for all of this. And now let's hear from somebody who's actually a county chairman and is in the process. And you in Pierce County, I believe you share staff with Madison County, my home county. And so we see a lot of that across the state where you'll see staff being shared by multiple counties. And so it's an efficient way of doing things. Take it away.
Thank you, John. Yeah, to reiterate what John was saying, Pierce and Madison County share the same zoning administrator, so it kind of helps streamline some of the processes. I'm coming before you today kind of wearing two hats. I am a landowner and farmer in Pierce County. Pierce County is a small rural county up in northeast Nebraska. And in 2015, NPPD built a 345 kV transmission line from Neely to Hoskins, and it went right through the middle of my brother and I. We farm together. We have a 2,500 acre farm, and that transmission line went right through the middle of it. And so we started, we didn't oppose it, and started just kind of thinking about what can this transmission line do for us as a benefit. So we started researching solar. And after it was a several-year process, talking with small-scale developers and just kind of educating us about what it takes to build a solar farm. We ultimately, with the help of Norfolk's Mayor Josh Moaning, who's a friend of mine, he knew what I was trying to do with building a solar farm, and his contacts with NextEra Energy led me and my brother to NextEra, and we signed up our 2,500 acre farm for a 423 megawatt solar farm. And that was in 2018. So after that process, I realized Pierce County does not have any rules and regulations for solar energy. And so I talked to my zoning administrator, Heather McWhorter. I said we should probably sit down and come up with some rules and regs. At the time, there really wasn't much. I guess I just need to back up. So for me, just wanted to talk about why I chose solar as a landowner. Diversified farming income. I was able to hopefully retire less profitable farmland It's sandier soils. It's not great for, honestly, it's not great for agriculture. Hate to say it, but it's kind of true. It can eliminate irrigation on those lands. We can eliminate the nutrient runoff that I'm sure many of you have heard about, groundwater contamination, the water contamination in the rivers and streams from all the nutrient runoff taking place across the Midwest. Can reduce chemical usage on those lands, increase pollinator habitat, and just wildlife in general. There's no noise or flashing lights to deal with a solar farm. And they're also small structures, out of sight, out of mind. But you don't see solar farms usually unless you're close to them. So it's a good deal. So when Pierce County went to adopt rules and regulations, at the time, there really was not very many counties, if any, had rules and regs to base ours off of. So we kind of had to, we relied on Google and my zoning administrator to try to figure out what can we do. And we kept it simple, as you'll see later on. So as the process where we had the public hearings to discuss the proposed rules and regulations was really painless. Nobody showed up from the general public to either speak in favor, opposition, or offer any inputs. Now, prior to me being on the Planning Commission board, about a year before I was on, the commission implemented rules and regulations for wind energy. That was a different story. I was in the audience for those meetings, and boy, they got heated fast. And so, yeah, that was it got tabled like 4 times before the Planning Commission voted to recommend the rules and regs to the county commissioners. So it was a complete 180 with solar. Nobody in Pierce County, at least at the time, nobody cared about solar energy. And I think it's because of the out of sight, out of mind. They're small objects. And as Lee said earlier, they're not much taller than a cornfield. And in rural Pierce County, everybody's used to seeing tall cornfields. So I know nobody's going to be able to read that, but I just kind of wanted to have our zoning regulations these actually are regulations. They're 4.5 pages. So I just kind of wanted to touch on the basics of it. We require a plot plan, as I'm sure most everybody else does now. Pre-existing solar panels are exempt from these rules and regulations. We've got definitions, as you can kind of see in the blurred. So the other thing is setbacks. By keeping it simple, we kind of treated a solar farm as if it were just a small building, if you will, just because of the size. So the main thing was nothing gets built within 83 feet of the center line of the roads. Otherwise, everything outside of that, it's kind of game on. So, and I realized that might not work for more heavily populated counties, but Pierce it did. Now, one thing I want to add to the setbacks, a year ago, Pierce County, the Planning Commission, we made an amendment to our regulations to implement setbacks for solar farms in relations to CAFOs, concentrated animal feeding operations, feedlots. We weren't prompted by anybody to do that. Our concern was feedlots can produce a lot of dust. And dust on a solar panel isn't great. We didn't really have any concrete data one way or the other, the effect on it, because solar is still so new. It's kind of in its infancy, as we know, across the Midwest. There's not a lot of other cases out there that we're able to say, okay, this works, this doesn't work. So the idea was, let's be proactive. The idea that I like about the setbacks is the developer and or landowner can always sign waivers of distance. It's not concrete. They can be voided if everybody's in agreement. It encourages discussion and cooperation amongst both parties. And I think that's what's key. Now, whether those regulations stay forever, I don't know. So what those were, I don't have them on the slides and I apologize. For 1 to 300 head, this would be in animal units. The setback is 0 feet. 301 to 5,000 head animal units is 1,320 feet. 5,001 to 10,000 head is 2,640 feet, which is half a mile. Above 10,000 head is 3/4 of a mile, 3,960 feet. So I just think it's probably the best thing because to have something in place for now, because if there was, and it could work both ways. If you have an existing solar farm and a feedlot facility wants to come in and build within 100 feet of them, basically upwind or downwind, upwind of the solar farm, it can just cause, it could potentially cause problems. Maybe it won't, but I just don't know yet. So we're just going to err on the side of caution. And vice versa. I think a feedlot probably wouldn't appreciate having a solar farm build right next door without them being consulted, because, and then if a developer were to decide, hey, this dust sucks, it's costing me a lot of money, your animals are costing us money, you guys have to pay for this cleanup of the panels. It just wouldn't be a good situation for either one. I might be completely wrong on that, but I figured I'd just we would err on the side of caution. Next thing is also landscaping buffers. We didn't specify that that the developer would have to plant hedgerows or trees. It just we wanted to have native grasses between the roads and the start of the project. Fencing, we kept that as predominantly open. Being in a rural county, we don't have that many people that are saying we don't want to look at solar panels. There was for instance, around my particular farm for the solar farm that I signed up with Nextera, there are 5 homeowners across or all around this solar farm, and I went out and visited with all of them before Nextera got their conditional use permit from the county, and all the homeowners didn't care, which was it was amazing. It was shocking. So I think, and then also with the open fence, the other thing that kind of reinforced that idea was visiting with our local volunteer fire departments. Their concern was we want to be able to see as if there would be a fire, it could be a wildfire, but it would sweep through a solar farm nonetheless. Because they wanted to be able to see as they approach the site where the fire is. I mean, you could also see the smoke, so you have an idea, but for their safety of their crews, which I understood. And so I don't think it wasn't a big deal, because I think that's probably the cheapest form of fencing. And it seems like that's pretty common around all the community solar farms that I've been around across the state. Seems like it's kind of standard. Everybody has chain link fences around their farms because it's a power plant. They don't want people walking around through there, potentially causing problems or getting hurt. We have a decommissioning plan. And the discontinuation is we went with 1 year of not being used for the decommissioning plan to be implemented. So, so the results so far, in February 2020, Nextera received a cut for the solar farm. Planning Commission and County Commissioner hearings went very smoothly. Obviously, I was out of the room for the Planning Commission hearing. I actually went and stepped out in the hallway. So I was away I missed all the action, if you will, but there really was no action. There was 20 to 30 people in the audience. There was one neighboring landowner, not a homeowner, just a landowner. He spoke in opposition just for the fact of he was concerned that a solar farm could negatively affect his deer hunting. And I told him before the meeting, like, really, if there's a chain link fence all around the property, it's going to funnel all the deer right through your property. You're going to have a haven or a mecca for hunting. But he didn't care. He didn't want that. So that's his right. Nobody has to like everything. So felt really pleased with how the process went. Last night, I imagine many of you people know David Levy. He was the representing attorney for Nextera. And we were talking about this hearing, and he was like, that was by far the smoothest hearing that he's ever been a part of when it comes to renewable energy project. And it went great because there was questions from the audience and everybody was civilized and they got answers from Baird, Holm, from Nextera. It was a smooth process. As far as long-term results, well, that's still TBD. Anytime in my opinion, anytime you put out rules and regulations, you don't know what you missed until you miss something and it becomes obvious. So that's why earlier in the year, we tried to amend our rules for a setback with CAFOs just to try to eliminate a potential conflict. But there will probably other things that seems like all regulations they evolve over time. So that is my presentation. So thanks, everybody.
Thank you very much. And now the last up, John, who's the executive director of NACO and is also their legal counsel. Did they pay you twice? Look at that.
Sadly, no.
No, just checking.
Thank you, John. Good morning. Good morning. Okay, slightly better. That'll work. My name is John Cannon. As John said, I'm the executive director of the Nebraska Association of County Officials. I've been in that role since February of this year, so if you see a new executive director next year, you'll understand that this didn't work out very well. Our mission at NACO is to represent all 93 counties. We've been around since 1894. Pretty long and storied tradition. We've had 6 executive directors in our history. I am the 6th one. And again, when I say, you might have a new executive director for NACO next year. I mean, we had an executive director. The very first one was there for a long time. The next one was there for a short time. The next one was there for a long time. The next one was there for a short time. And the last guy was there for a long time. And I'm sensing a pattern emerge. And so anyway, on your remarks, please make sure that this is the best presentation you guys have seen at this conference. As John had mentioned, we advocate for local control. That's really what we're about. And it's a very interesting dynamic that we have with the state. We have a statutory framework, and the reason I want to mention a statutory framework is because counties are creatures of the state. We observe what's called the Dillon Rule, which means that counties don't have any authority that's not explicitly granted to them by either your constitution or your state statutes. And so when it comes to everything that we're talking about here today, planning and zoning in particular, we are driven by what the statutes have to say. And so in general, you've got Chapter 23 talks about zoning. I've got the sections up there for you, 23-114 through, there's a whole mess of them. And I'm assuming, John, these slides will be available for everybody.
Yep.
Yeah, so you'll have this there. And then Chapter 66 is for wind and solar. And I mentioned in here, you can't really tell, but it says section 66.914 and 66.914. So some intrepid observer is going to go to the legislature's website, click on 66.914 and say, that's not the answer I was looking for. I'm going to go back and now I'm going to click on the same statute again. My apologies. It's actually supposed to be 66.913 and 914. So that was a typo. My apologies for that. So in Nebraska, this is the zoning status of Nebraska counties. Right now, we have 83 counties that have zoning, and they've adopted the comprehensive plan and they've adopted zoning regulations. But then you've got counties that have only adopted the comprehensive plan, and then you've got 3 counties, and that would be Platte, Butler, and Nuckolls that don't have any zoning or comprehensive plan at all. And so the counties that are without zoning, you have them here listed: Banner, Blaine, Dixon, Nemaha, Richardson, Thurston, and Wayne all have the comprehensive plan but have not adopted zoning regulations. And like I said, Butler, Nuckolls, and Platte do not have anything. The counties with the comprehensive development plans have undertaken the necessary first step toward having zoning. These counties don't have zoning until they've adopted their regulations. Many of the comprehensive plans were adopted 15 to 20 years ago. And as a lot of you know, a lot of the action around wind and solar has really occurred since then. And so there aren't a lot of counties that have actually updated their regulations to account for wind and solar. And so they would either have to start over or they'd have to modify the comprehensive plan and their zoning regulations in order to do that. So the counties that have zoning would be the remaining 83. There's 93 counties in Nebraska. If 10 counties don't have it, that means that 83 do. So for anyone that's not a math person, I was not. That's why I went to law school. So anyway, zoning, you have to have it in order to regulate wind and or solar. You have to have your comprehensive plan and a resolution. You have to have a planning commission. You may have a zoning administrator. It's not always required. And you must have a board of adjustment. So the planning commission, in order to implement zoning, county board must appoint a planning commission. Members must be county residents. They prepare and they adopt zoning regulations and plans. They hold hearings. They look at conditional use permits. They approve and review a lot of different things in the community. County boards may not take action on zoning related issues unless they've received a recommendation from their planning commission. And again, the commission can authorize conditional use permits and special exceptions. The authority for the planning commission comes from Nebraska Revised Statutes section 23-114, and then there's a whole host of statutes right after that kind of fill in the blanks as far as what their authority is. So next we have the zoning administrator. They may be appointed. They may also be a building inspector. For some reason, someone thought that was important to put in the statute. The statute that you would find this under would be 23-114.04. And then the Board of Adjustment, their general authority comes from Nebraska Revised Statute section 23-168.03. They may take appeals of any decision of either the Planning and Zoning Commission or the County Board. They may authorize variances to the zoning regulations in exceptional cases, and any appeals from the Board of Adjustment goes to district court. There's a specific time frame after a decision by the Planning Commission. Usually it has to do with unique circumstances is when you would appeal to the Board of Adjustment. They may hear appeals on conditional use permits, which is kind of a big deal, and typically appeal to when the property owner does not get the result they want from the Planning Commission. So a couple of observations that we have. This is, and again, I just wanted to kind of give you the framework, the statutory and regulatory framework that we have in the state of Nebraska, and a couple of observations. Again, cannot emphasize this enough. The comprehensive plan is only a first step. We've got 7 counties that have only adopted the comprehensive plan. Zoning is becoming more and more of a battlefield for hot topics. The people that are in this room are probably acutely well aware of that. Wind and solar in particular have become more politicized. And county boards have been more and more apt to kind of put off making their decisions until they've received sufficient information from either the developer, the landowner, or any other members of the public. And so there's a lot of coordination that goes into these sorts of things. And so for those of you in the room, I guess the best advice I can give is, try and get that information out as quickly as possible and start developing those relationships that you have with developers, landowners, etc. For best practices, get community input and involvement. One of the things I do as I go across the state is, I advise county boards, have town halls, hold open a portion of the county board meeting for public comment on whatever the issue is that you want to have them comment on. Develop those relationships with your newspapers so that you can, get that information out that way as well. And then also accurate information is necessary. And again, that is why you'll see more and more county boards that are holding off on their decisions until they get that information in front of them. So the counties that have solar and wind regulations in place, this is out of the 83 zone counties that responded to our survey. I will note it's a couple of notable exceptions. We did not hear back from the big 3. One of the nice things about NACO is that we put a whole bunch of information out for our counties, and a lot of them say, well, now we can more efficiently ignore that, so thank you very much. We send out these surveys, and we get back responses. When I prepared this slideshow last week, we'd only received responses from 30. We actually got responses from 34 counties. 33 of those 34 have wind regulations in place, and 24 of those 34 have solar regulations in place. And again, this is not an all-inclusive list, missing the big 3, and notably, I think Antelope and Holt did not respond to our survey as well. So that just recognize this is not all-inclusive and doesn't account for every county in Nebraska, but we did try to get you the information that we could, and we usually have more information that we warehouse. Please feel free to contact me or any of our staff. If you have questions about what our county's doing, we typically survey them on about an annual basis. So solar and wind, all counties with zoning are authorized to include considerations related to solar and or wind energy. We specifically wrote that into Nebraska Revised Statute section 66-913, the missing statute from earlier in this presentation, and may include but not be limited to regulation of height, location, and setback, and regulation of the use of structures, etc. And you could read that as well as I can. When zoning regulations would prevent or unduly restrict the use of solar and or wind, the governing body may authorize variances and exceptions, and so that's why we have the appeals that we do and the process that we've described. And that's really about it as far as the framework that I have. Additional resources on our website, NACONE.org. We've got a number of resources related to counties and planning and zoning statutes, and then NPZA, which is the Nebraska Planning and Zoning Association, npza.org. They've got a number of resources for you as well. I always have a question slide, but I think we're going to be taking questions as a panel, so I'll skip over that and say thank you. That's my contact information. I have business cards if you'd like them. That's my cell phone number. I give it out willingly. Perhaps that's a strategic error, but happy to take phone calls from anybody. I took a call on Saturday night about not wind and solar, but county issues, and that's kind of what they're paying me for, so I'm happy to do it. And that is all I've got. And I think, John, we just have a panel discussion for questions. Yep. So I'll turn it over to John.
Thank you. So right off the bat, I have a question, which is, how does this work again in those counties that do not have planning and zoning in place for both solar and wind? And how does that process work?
So as far as how the process works, it's really going to be up to the landowner, because you don't have zoning that says, here are the restrictions that you're going to place on your land. And so is what we've advised our counties is that if you want to be able to regulate wind, solar, or basically anything from a zoning perspective, you've got to have zoning in place.
In the absence, if they don't have planning and zoning in place, is it possible to just do whatever? Then there's no real rules to the road. There's nothing that the county needs to do to say this is a permitted activity?
We have advised our counties that if they don't have any rules in place, then they're going to have a very difficult time controlling landowners from making use of their property the way that most people conceive of landowners making use of their property.
Okay. So if a county has planning and zoning in place, but they don't have solar regulations in place, then is it not the case that you can't build a solar project until the county determines whether or not it is a permitted activity and how that might proceed?
We haven't really discussed that at length, but I'm going to turn it over to Lee, who has an answer at the ready.
I think I can weigh in on that. So typically if a county does have zoning regulations in place but does not have wind or solar regulations in place, the regulations say that any use that is, or the zoning regulations say that any use that is not detailed herein is prohibited. And so in that way, a lot of times they are prohibited unless they fall into a utility catch-all or other provision, or unless the county passes those regulations.
I always appreciate it when you can get free billable hours out of lawyers. That's because we had the issue come up in Lancaster County, and so can there be solar development? Well, not until the county developed the solar provisions. And so I was asked about that question, not real sure. I thought, well, if you don't have rules and regulations, it ought to be permitted. But in fact, that was not the case. And then I've had folks ask, well, if that is the case, why then in Wayne County, for example, where they don't have planning and zoning on board, why were they able to move forward with all the wind development? I think we've put that to bed. So, but it is interesting what is permitted and what is not.
I would just add that even in the counties that don't have zoning, the county has limited governance and that you'd still need a building permit to construct the project.
So you still might need a building permit even though they don't have planning and zoning in place.
That's right.
Okay. Questions?
So if a county puts a zoning rules in place and a project comes forward that fits those rules, it can say it's a wind project and it complies with all the zoning regulations, and there's really strong opposition to the project in the county just because, do the supervisors have any obligation to abide by the statute they've adopted, or can they kind of be nimble on their feet and say, we're just not going to do this because it's not popular?
Sure. Well, you're going to get different opinions on the local governance on that. I've certainly been in boardrooms where they say, you know what, I don't like it, but the regulations allow it, and I'm going to vote in accordance with the spirit of our regulations, which I think is a very rational approach. But I've also seen the opposite. And so I don't think you're going to get any consensus on that question, unfortunately.
Yeah, what we advise our county boards, commissioners, and supervisors is that if you've got regulations in place, you're well advised to abide by them. If, however, you need more information, that's something you can table to a future meeting. And I would hate to refer to any county boards as falling back on that, because it is a little bit gutless, but sometimes they do, and I'm sure they have very good reasons that are not gutless for doing that. So it's like Lee said, it's just going to depend on how much pressure they're receiving from the public.
So to follow up on Chuck's question, I've often wondered this as you, for example, I'm a recovering NRD public official. So you develop cost share programs, you do all of these things. So as members of the public come forward, if they fit the criteria that you have for that program, you are pretty much honor bound to accommodate them. You don't say, well, we like Al, we don't like Fred. It's everybody gets to participate on an equal basis, unless there's some overwhelming reason like fraud or something like that. So based on my background in that arena, it has always struck me that if a county goes through the process of developing rules and regulations, which are the rules of the road, and the rules of the road are clear, and the developer has met all of those rules and all of those criteria, then it would seem that the county would be fairly compelled to approve the permit as long as all the criteria has been met and they have the sufficient information and all the boxes have been checked.
Yeah, and John, I agree, and that's generally how we advise our counties. One of the very first things we do is we say you need to have your county attorney involved from the get-go, because generally they're supposed to be the impartial yet passionate advocate for you that's going to advise you as to whether or not you're going to get yourself into hot water if you don't abide by the regulations that you have in place.
Based on the hot water comment,
Uh-oh.
is there a potential for legal action on the part of the developer if, in fact, they have met all of the criteria and the county has less than a clear reason for denying a conditional use permit?
Well, John, when you put it like that, I'm going to say that no one should sue any counties ever. So, but I'll let Lee decide, whether or not he wants to make the case for the developers.
I think the answer is yes. There are certainly times where you could take legal action, but that would be an absolute last resort. When we go in and want to develop something, we want to build a lasting relationship with the county, with the landowners, and obviously these projects they have a long life cycle. So unless there's a really egregious issue, we're going to reserve that.
So more likely a public relations consideration than a legal one.
That's correct.
Okay. We are just about at time. We've had an excellent panel. Let's give them all a good round of applause.